Hello everyone, I welcome you all to another video by Legacy IAS where we are going to continue our discussion of dispute redressal mechanisms and the different institutions which come with it. So here we are going to talk about two very important institutions who hold an important position, have gained a lot of national attention, have become a point of dispute redressal for many, especially the poor and the weak. All right, so in that context, we are going to look at these two institutions and how they further strengthen political democracy, provide justice to all, and fulfill the principles enshrined in our preamble and the basic structure of the Constitution. So, in this particular video, we are going to talk about the public interest litigation. Now, if we look at the word public interest litigation, we are essentially obviously referring to something that is to be done in public interest, all right, or there is an issue that has to be looked up in public interest. Now, if we look at any case in the traditional judicial system, we have people who are filing their cases or who are fighting the cases are the ones who are in some way or the other affected by it. So in public, in like family matters or commercial business matters, they are kind of directly affected by it. So in that sense, in terms of directly getting affected, it's kind of personal. But here we're talking of issues which are actually in larger public interest, which may or may not affect you directly or at this particular point of time. This kind of a thought process is something which arose out of awareness of how we need to kind of look up towards our justice system, towards our society, and there are some things which are just so very important. And there's also realization that there are some sections of the population who are affected by it, but they're not capable enough to kind of go through this process of getting themselves justice in a more efficient and effective manner. So keeping all of this background in mind, we had the system of public interest litigation being introduced in India. Now, so this basically means, PIL in short basically means that it is a litigation which is of course filed in a court of law for the protection of public interest, all right, something that affects the larger public, not necessarily at this particular point of time it affects you. For example, pollution. Now come winter months and pollution is a problem which is a highlight in the national capital. It is very, very unfortunate that really you have the national capital being troubled by not a lot of its own reasons, but because of how geography is for that particular capital. Issues like terrorism, it's not necessary that it will affect you. God forbid it doesn't affect anyone, but it may affect anyone for that matter. So it is a concern for which the entire society needs to come forward. So on issues like this, for example, road safety, especially during the rainy months, the monsoon months, there's such a big problem because often at times it happens that you have cars and motorcycles kind of getting affected by it, by potholes and accidents. So moreover, construction hazards, a lot of these issues are all together something that is not necessarily particular to a particular individual. Although the main and the only focus of such litigation is public interest, although the main areas of focus of basically such litigation is public interest, there are a lot of other areas also, okay, various other areas also where this particular PIL can be filed. And that is what we're going to study now. Some things can be violation of basic human rights for the poor, all right. Some other issues like violation of human rights, content or conduct of government policy, the way in which the government policy is functioning, that is something that requires attention. How municipal authorities are really expected to perform their duty at the grassroots level. It's important for them to kind of ensure governance, not just for municipalities, even for panchayats for that matter. Violation of religious rights or other basic fundamental rights. So anything relating to fundamental rights becomes primary in terms of its compliance, in terms of its enforcement. So these are some of the other such examples whereby PIL can be filed in not just issues that just concern you. there needs to be an understanding that there is a why, there is a very important need behind this PIL, because we've seen that in terms of in the past before PIL, there was hardly any link between the rights which were guaranteed by the Constitution and the laws which were made by the legislature and implemented by the executive, of course, and the vast majority of illiterate citizens on the other. So we essentially were looking at a huge amount of gap. Now, as it is, when you look at the constitutional provisions or laws, the language that they have, they're also alienated from the poor. It's almost like how the Vedas were alienated by the Brahmanas from the rest of the population. So to kind of bridge this gap, to kind of ensure that what's written in the Constitution, laws are made accordingly, and that's been understood by the large section of the population, there was this entire view accordingly. The traditional view basically in terms of this kind of jurisdiction revolved around the fact that you can basically file a case if you have suffered a legal injury, or a legal right has been violated, or for that matter, you're likely to suffer in future a legal injury by reason of violation. Now, this particular concept has been changed in India as far as the PIL in India is concerned, because here we are having a much more improved version that was there in something which we borrowed or influenced from the United States of America. Now we have a public interest law that is in the name, that has recently begun efforts to essentially help in providing legal representation. All right, provide this platform to ensure legal representation to the earlier unrepresented groups or such unrepresented interests or issues. All right, in this regard, earlier only the affected parties had, or rather had the opportunity to file a case. Now, even if you are not directly affected in the case, now through PIL you can actually go and raise that particular issue in court. So they were not allowed to continue their litigation, and only the affected persons were the ones who could basically go ahead and file a case. That has now fundamentally changed because of this public interest litigation, and this is where the importance of it kinds of becomes very, very crucial. Of course, there is problem with regards to pendency. Of course, there's problems with regards to lack of specialization sometimes, but nonetheless, we've managed to at least create that institution, and the improvements can go on further. So that takes care of our discussion of public interest litigation. Now moving ahead to another such institution or mechanism for dispute redressal, that is Lok Adalat. Now, just like we tried to do an etymological study of public interest litigation, Lok Adalat essentially means people's court. All right, so it is again an alternative dispute redressal mechanism, essentially a forum where these disputes or cases which are pending in the court for a very long time, or sometimes they're too expensive to be executed, they're pending in the court or at the pre-litigation stage, all of these cases are actually settled and compromised, or rather kind of discussed about, right? So you have essentially settlement, resolution of these disputes, alternative to the existing Supreme Court, High Court, trying to have a people's court in this regard. Here they have been given a statutory status, and the authority from which, the act from which it draws its authority, is the Legal Services Authorities Act of 1987. Now, under this particular act, the award, or rather the decision that is being made by the Lok Adalat, is referred to as or treated as the kind of a judgment which is being given by a civil court, all right, and it's final. This much of importance, authority and right has been given that its decision is final and binding on all the parties, all right, and no appeal against such an award lies before any court. This is a very, very important point, that here we are really, when India speaks of democracy, we're trying to create really like people's court, whereby they are the ones who understand the requirements, and for the public that particular decision has been made equivalent to a civil court, and it cannot be continued or it cannot be challenged. Now, if the parties are not satisfied, of course, that particular disclaimer has to be given. What if the judgment is incorrect? Such kind of a safeguard is being provided. There is no provision for an appeal against such an award, but they are free to initiate litigation. All right. How do they do that? By approaching the court of an appropriate jurisdiction, by filing altogether a case in which they have the right to litigate. So even though it is something which is filed in the Lok Adalat, but let's say that particular issue falls within another court and it is in the jurisdiction of another court as well, so they can file a case there if they are dissatisfied with the judgment. All right, but this particular judgment in itself cannot be challenged. That is a very significant part as far as Lok Adalats are concerned. Moreover, very, very important, we are trying to make this kind of justice free from any kind of payment. We're really making an attempt to kind of support the unrepresented, and in this regard, there's no court fee that is being payable to any matter that is being filed in the Lok Adalat. In fact, if a matter is pending in the court of law, is referred to as the Lok Adalat and is settled eventually, the court fee originally paid in the court on the petition is also refunded back. It's such a novel feature. What does it mean? It means that even though there is a particular case which has been pending in another court, but now that you've brought that particular case because it was pending there into the Lok Adalat for resolution, now if you've paid a certain amount of fee in the previous court, now that it is being done through Lok Adalat, that particular amount is refunded back to you. So it's something that's really trying to provide justice for all and justice to the poor. So the persons deciding the cases in the case of Lok Adalat are the ones who are statutory conciliators only, all right, and do not have any judicial role. They can only persuade the parties to come to a conclusion for settling the dispute outside the court in the Lok Adalat. In this regard, the members shall assist the parties in an independent and an impartial manner to help them reach the settlement. A lot of times these out of the court settlements really go a long way in terms of reducing the burden that is to be there on the courts, taking time, money, energy, and also sometimes helping them reduce the embarrassment, especially on the ones who are accused. So in a lot of ways, these out of court settlements kind of go a long way. Also, we need to kind of look at the different kinds of cases which can be referred to a Lok Adalat. So you can have a case which is pending in any other court that can be brought before the Lok Adalat. Also, any dispute which has not been brought before any court and is likely to be filed. So one which is already pending, one which is yet to be filed. Okay, all these kind of cases, which practically means any kind of case which can be brought before Lok Adalat in a lot of ways. There's a particular type of Lok Adalat which is called mobile Lok Adalat, which are organized actually in various parts of the country, whereby the people, or rather the courts in itself, they travel from one location to another trying to resolve disputes and have these resolution of disputes. You know, there are these camps, medical camps, which also kind of go from one place to another trying to resolve the medical issues that are there. Here we're trying to solve the kind of judicial issues or legal issues that may be involved. So in that sense, these mobile courts are there, which are trying to ultimately help in providing governance to the country. Also, as far as the composition of the Lok Adalats is concerned, the levels at which they are there, now at the High Court level, the composition is such that the Secretary of the High Court Legal Services Committee is essentially going to constitute benches comprising of sitting or retired judges of any High Court and any of the both. Basically, they have to appoint member from the legal profession, a social worker who is essentially involved in the upliftment of the weaker sections, and those interested in the implementation of the legal services or programs. So the kind of outlook that one is supposed to have, of course, you have a judicial person, someone from the legal profession as well, but there's a very important contribution of someone from the weaker sections to be present there for their upliftment. At the state authority level, we have this member secretary of the State Legal Services Authority organizing a bench, again, which is someone comprising of someone from the legal profession and a social worker engaged in the upliftment. At the district level, we have the secretary of the District Legal Services Authority, constituting benches of those comprising a retired judicial officer or any one or both, either from a legal profession or a social worker. All right, and here one thing is also very important, that you have someone engaged in paralegal activities as well, preferably a woman. So we're trying to have more of gender representation as well in this regard, and the kind of novelty with which this composition is being done speaks volumes about the kind of output that you can expect out of this Lok Adalat. Now there is also, just like the mobile Lok Adalat, we also have the national Lok Adalats, which are held at regular intervals, all right, where on one single day they are held throughout the country. So there's a national Lok Adalat which kind of comes at regular intervals on one particular day in all the courts from the Supreme Court till the taluk level. So here you have like speedy execution of justice. All right, so in one particular day you have like all these pendency of cases starting all the way from Supreme Court to the taluk levels. These kind of courts are organized, which is just trying to create this initiative to have the speedy disposal of justice, because justice delayed is justice denied. So the success of this is that from 2015 they have been held on a specific subject every month, which is actually a great initiative in this regard. Also, we have something called permanent Lok Adalats. The permanent Lok Adalats are actually organized under the same authority, the Legal Services Authority Act of 1987, under Section 22B. They've been organized at permanent bodies with a chairman and 2 members who are appointed for, or who are important for, pre-litigative mechanism for conciliation as well as settlement of cases on matters which are relating to public utility. Now, what are the matters relating to public utility? Like transport, postal, telegraph, etc. So we have specific areas mentioned, we have the composition mentioned, and we have the objective mentioned, which is conciliation and settlement of cases. So even if the parties fail to reach to a settlement, the permanent Lok Adalat gets jurisdiction to decide on the dispute, provided that the dispute does not relate to any offence. Further, the award of the permanent Lok Adalat is final and binding. Now, this particular element really adds a lot of value in terms of what we're trying to look at in terms of the final resolution. So I hope you have gotten a good sense of both the public interest litigation as well as the Lok Adalat through this particular video. Please share it with those who don't know about it. And if you've liked it, let us know by liking the particular video. Alright. Subscribe to Legacy IAS to continue watching the rest of the dispute redressal mechanisms.